Hello, this video is about how to give evidence in court. Now, as a barrister, I'm not going to talk about what your evidence is, or you shouldn't rehearse it either. But witnesses are often confused about how they give evidence. And sometimes a witness, either in the witness box or wherever, stumbles over matters. And what the court wants, whether it's a judge, a jury, a tribunal, what they want is the witness's evidence. Now, the court has a conflict. Two sides giving it two stories. So it's the court's job to sort out what's what. Now the witness just has to give their evidence, what they know. My top tips for a witness in giving evidence sound simple, but I've seen in court so many witnesses fall over themselves. So what I advise is 1. Listen to the question you're asked. 2. Think about it. 3. Answer it. Sounds simple, but I'll try and explain. 1. Listen to the question you're actually asked. It's going to be nerve-wracking, so if you can get to the court a day or so beforehand or see it before, that's always a good thing. But often I've seen witnesses and you can tell they're thinking about things. Now I'll give some examples, and I'll give some deliberately everyday banal examples. But a witness might, in the witness box, be thinking to themselves, I'm going to be asked about going to the shop. They've got this running around in their head. The first question the barrister from the other side might ask is, what was the weather like that day? The witness is flustered. So try to calm down and listen to what you're actually asked. By your own side, the other side, the judge, whoever. Don't worry about the questions you're being asked. It isn't your role as the witness. You have a key role. Your evidence. No one else has your evidence. And the court wants that evidence out so it can assess what to make of it. My second tip is think about it. I've just paused there. People do naturally in conversation. Perfectly ordinary. But in the witness box, time can either speed up or slow down. Having listened to the question, think about it. If you're not clear, ask. Don't play a game with the other side's barrister or the judge. No, be clear about what you've been asked, think, and answer. And if you can answer straight away, fine. And if you've really got to take a few seconds to recall, that's fine as well. My last top tip, answer the question. Some of the best evidence as a barrister I've ever heard in court has consisted of witnesses saying things like, I don't know, I wasn't there, I've forgotten, that wasn't part of my job, I knew at the time, I noted it down, but I just can't recall now. And why? Because I've also seen similar witnesses, and again I'll give everyday examples, saying things like, no, it was definitely a Wednesday. No, it was the shop, not the office. And what that means is the court, judge, the jury, whoever, they know where they stand with that witness. They don't gild the lily. When they don't know, they say it. So when they do know, well, possibly they're more credible. So, to sum up, think, answer the questions, take your time. Thank you very much.